Hello friends, in the series on the income tax cases, today we will discuss another very important case which is based on the allegation of the bogus purchases by the assessee. In the present case, the issue before the Honorable ITAT bench Mumbai was that if the assessee submits the primary evidences and disposes of his primary burden to prove his transaction genuine, then the onus shifts on the assessing officer for the rebuttal of those evidences. And the issue was that if the assessing officer does not rebut the evidences submitted by the assessee, so whether in that case the addition just on the basis of the statement and on the basis of the investigation report is justified. This issue has been taken up by the Mumbai ITAT bench in the case of Indravadan, Hanjarimal Jain versus Deputy Commissioner of Income Tax, and this case is reported in 127 ITR Tribunal at page number 352, and the date of the judgment is 4th April 2025. In the present case, the notices under section 148 were issued to the assessee for the assessment years 7, 8, 8, 9 and 9, 10 on the allegation that the purchases made by the assessee are not genuine and they are bogus as per the statements recorded by the investigation wing and as per the DDIT investigation report. During the assessment proceedings, the assessee submitted before the learned AO that the assessee is a contractor of government civil contracts, and the assessee submitted the mountain of the evidences which include the purchase details, the confirmation of the suppliers, the PAN number of the suppliers, the addresses of the suppliers, the bank reflecting the payment to the suppliers, and the register of material inward and outward. But the assessing officer, while concluded the assessment just on the basis of the statement of the third parties and on the basis of DDIT investigation report, and added the whole amount of purchases into the income of the assessee even without refuting the evidences submitted by the assessee, without providing the opportunity of cross-examination to the assessee, and without providing even the relied upon documents by the assessing officer. When the matter came before the CIT appeal, the CIT appeal dismissed the appeal of the assessee in limine, and when the matter was before the tribunal first of all said that in the present case, the whole assessment has been completed on the basis of the statement of third parties and relied upon documents which has not been provided to the assessee. So, in the case when the opportunity of cross-examination is not given to the assessee, the assessment is not valid. The tribunal said that since there is no rebuttal by the learned assessing officer for the evidences filed by the assessee, and the relied upon document has not been supplied to the assessee, the addition is not justified. The tribunal noted that in the present case, the assessee has been successful in explaining the transactions made by him. The tribunal said that once the primary evidence is submitted by the assessee, in that case the onus shifts on the assessing officer for the rebuttal of the primary evidence. The tribunal said that the purchases has been made by payment through check, and even the payments has been received in bank accounts from the parties to whom the sales have been made. The tribunal said that in the present case the purchase and sales are genuine and the sales has not been doubted. So without doubting the sales of the assessee, the addition for purchases should not be made for the full amount. The tribunal said that since in the present case the assessee is showing a handsome amount of GP and net profit ratio of over 8% over the 3 years, so in that case also even the addition for GP cannot be made on the purchases made by the assessee. The tribunal said that in the present case there is a gross failure on the part of the assessing officer for the non-rebuttal of the evidences filed by the assessee, in not providing the opportunity of cross-examination to the assessee, and in not supplying the all the material which has been relied on by the assessing officer and even the copy of the statements to the assessee. So the addition is bad in law, and even no addition was being made for the percentage also. At the end of this video, once again I am repeating the name of the case, The name of the case is Indravadan, Hanjarimal, Jain versus Deputy Commissioner of Income Tax, and this case is reported in 127 ITR Tribunal at page number 352, and the date of the judgment is 4th April 2025. Thank you, friends.